There is a way to do things, then there's the legal way of doing things. Today I'm with Michelle Thomas, attorney at law, as we discuss real estate law 101. Hi, Michelle.
Hi.
Why do I need a lawyer if I'm buying a home?
Why not? Of course you need a lawyer, because in doing any transaction in Jamaica, you need a legal support who will guide you, who will ensure that what you're actually buying is actually proper and in the correct form, who will ensure that the process is seamless. Oftentimes you as a layman will not know what to look for. No, your lawyer should check the title to ensure that there's nothing, no encumbrances, no liens, no caveats that will affect the transaction. So that is an important factor to take into consideration.
So in a sense, you ensure that it's a legitimate transaction, and you ensure that there are no impediments to the transaction.
Simple.
As
Correct.
my attorney, what other services would you do?
So they guide you along the way. You know, after you pay your deposit, the attorney will instruct you to go and get your valuation done. And that is just to ensure that when you're purchasing the property, you're purchasing it for the correct market value. Because sometimes people will say they advertise it for 12 million, but really and truly it values 10. Now, if you did not know that, you will be buying a property without equity. So your attorney will guide you in terms of the relevant third parties that you will need in order to fulfill the requirements. So another important factor is boundaries, whether or not the property is encumbered, whether or not the property has a breach.
Yes.
And so you'll have to get a surveyor to ensure that the boundaries are in the correct places and the property is not breached, because if it is breached, you have another hurdle. Mortgage institution will not support an application if you do not give an undertaking to address that. So that is something that the lawyer will point you to. Also, the lawyer will look at the documentations that you'll have to sign. So you have to sign a sales agreement, an instrument of transfer, and all of that is drafted by the attorneys, passed on to the attorney for the purchaser, and your attorney will have to look over the documents to ensure that there are no clauses that will prejudice you in the transaction. And one of them might be, let us say, a forfeiture clause. I will not advise any client to sign one that has a forfeiture clause, because it means that if you're not able to fulfill the arrangement, then you will lose your deposit.
Wow.
Right, so sometimes you have agreements that encompasses forfeiture clauses, things that may be a little extraneous to the purchaser, and so you have to have a lawyer that has your best interest at heart to go through the document, ensure that what you're signing to will not be a bother in the future.
I didn't know all of that, so thank you for getting into all of those details.
Yes.
What are some of the pitfalls you've seen as a lawyer as people try to acquire property?
Well, one major one is that people need to understand, especially for rural land, that gone are the days that you just see a land being advertised, you pay the money, you get a receipt and say, oh, I own the land. No. We are encouraging people not to do those type of transactions, but really and truly to ensure that when you pay for land, you get an actual title. It's not okay. And that is a major pitfall. Another one too is when persons overseas, they see land being advertised in Jamaica, they send down the money and then, oh, they're excited, they're getting a deal. And when they come, it's not habitable. It's basically a sinkhole. And so it's not every land that is being sold is for the intended purpose that which you want. So there's a distinction between farming land, a residential land, or a land that is not fit to have anything done on it more than just be a land.
So I shouldn't buy property on just pictures and posts that I've seen online.
It is very important that you as the buyer be prudent enough to go into the area, do some research. So if you see a nice little house with a white picket fence and you say, oh my God, this is the mansion house, go next door and say, ma'am, sir, I'm intending on buying that property next door. Did anybody die in it? Is there anything that I need to know historically about this place? Because sometimes you have haunted houses. Sometimes you have stories that, if you really know the genesis about the house, you would not buy it. Sometimes the community will tell you that house, it have problem when rain falls, it's not just seeing something and say, okay, I found my mansion. It's actually doing market research. Even getting a contractor to come and look on the structure and give your opinion on,
yes.
the structural integrity of the building.
Yes.
And so all of that is something that you have to take into consideration.
And that's something that my lawyer will guide me
a good lawyer,
yes.
a very good one, might I add, will tell his or her client these are. So they will give you a checklist and they will ask these questions. And if you tick and it's in the affirmative, then they will say go ahead.
But what if I'm not trying to purchase property, but I've been living in this house for years? This is my family home, but it may have been willed to somebody and they're trying to get me out. But this is, as far as I know, this is the only home I've ever had.
That's a very good question. In fact, that is a reality for a lot of persons. In fact, my answer to this is if you're living on a property and it's registered land and you're there for more than 12 years undisturbed, paying taxes, maintaining the property, and you have two people that live in close proximity that can attest to you being there occupying it to the exclusion of the registered owner, it is essentially yours. It's called adverse possession.
So if I'm living on this property 12 years undisturbed, but I have to be paying the taxes, the property
paying
taxes,
the taxes and
maintaining it like my
treating
home.
it like it is yours, maintaining the property, they're in occupation, it is considered yours by law. If that person does not probate the property in time to oust that person who's there for 12 years, you have no claim. Because what happens is when you really have property that is a part of our estate, you have within 1 to 3 years to get that will administered. And once it is probated and you pay the relevant debt duty taxes, you are supposed to give the property to the beneficiaries named in the will. If that is not done and you're there sitting in the property and making the property your own for 12 years undisturbed by the beneficiaries and or the executors, it becomes yours.
And what is probating a will?
So probating the will is the process of ensuring that the executor who is responsible upon a death to administer the will, so to put the will through the courts to authenticate the will, and the court will give you what is called a grant of probate. That is a document that will assist the person, the executor, in putting the names of the beneficiary on the title to transaction all the business based on the wishes of the deceased. So it has to go through the court because the court is a public record.
So once you have land, you need to have a will.
Yes.
Or any type of property.
I would recommend, because a will really articulates the wishes of the person upon death. And let me tell you, so when the family dynamics is very wide and you have outside people and side people, you want to ensure that you protect the interest of those who you really love. So you will see that persons might have like 12 children and them have like 5 baby mother. What happens in those situations? Everybody start fight over who forget what. So in the real world where you have a lot of dynamics in terms of children and baby mothers and wife and all of that, as a responsible individual, it is important that you document your wishes to ensure that upon your death, somebody's not crying too harder than so.
And do I need a lawyer to do a will?
I would recommend. I have seen in cases where people go and they do their will with a JP and then they don't understand some things. So for example, if you have a property that is owned as a joint tenancy, in a joint tenancy situation, you can't will it because it's locked between the other person that you are not a joint tenant with. People don't know that, so they go to a JP. Yes, the JP will witness a document and all that, but in terms of certain formalities, they will not know. And whoever is your beneficiary cannot be the person who is witnessing your will. Some people don't know that, so if the JP is not sufficiently seized of certain knowledge, then you can have a will that becomes void.
So we've been hearing a lot now about having a trust versus a will. What's the major difference?
It's inextricably linked because, for example, in the will, you can itemize that you're setting up, for example, a trust for the child. So, for example, if there's a minor and you want to ensure that somebody holds the asset until that minor attains a certain age, because you don't want to just give a gift to a child that is not able to really manage the gift properly. So you set up what is called a trust, and that trust can be itemized in the will, and the person who is the trust holder will have certain responsibilities. So it is linked together. Trust are normally is formalized in the will, and it can be done separately. For example, if you transfer the property inter vivos, meaning whilst the person is alive, they can endorse the interest of the child on the title to be held until a particular time.
We've been learning so much with Michelle, but there is much more to come right after this break. We continue our conversation with Michelle. So let's move away from owning property to now renting property. Is there the need for a rental agreement, a document that's signed between myself and the landlord?
It is important to have a rental agreement that sets out the covenants, sets out the contractual arrangements between you and the tenant versus the landlord. And that will kind of guide the transaction and navigate it based on the needs of the landlord. However, where it gets really tricky is that after 1 or 2 months of not seeing rent, and then the person feel like the property is theirs, it becomes muddy, because then a lot of people don't know this. You can't just go to the person's house and throw them out. In fact, you have to give them a notice. And if you give them a notice for non-payment of rent and then they pay the rent, you can't just throw them out, because the notice was specifically for non-payment of rent. So upon payment of rent,
that becomes null and void.
It really null and void notice. A lot of people don't know that. So they will say, oh, lawyer, we give them notice for non-payment of rent and I'm still there. But by them paying the rent, it nullifies the notice. So another thing that persons don't know is your notice has to be for a 30 days period. So you have to wait the time period, and if they don't leave after the 30 days, you can't just throw them out. You can't get a bailiff, and you can't just get a friend or a bad man and fling them out, because then you can be brought to court for that, and you can't be a nuisance to them.
So how do I get someone out of my property after the notice?
Perfect question. You will have to take them to court to what is called a recovery of possession proceedings, where you exhibit the notice that you would have served them and indicate to the court that upon serving them they did not leave the premises. You will get a court date, and then you will have to attend, make a case before the judge, and the judge will ask of the tenant whether or not it is true and give them time again, because I would like, they do shed leniency on the tenants, so it's not a case where automatically when you go before the court you're going to say leave. The judge will ask you when it's it, how much time you want. So the landlord again have to wait, especially if it's before the court, for the time period. And then after the time period, if the tenant does not leave, they can get the bailiff involved. But not even just that, they'll have to go back to court and file what is called a warrant of leaving.
No, Michelle, this sounds
so it
like
is
a
really
2-3 year
lot.
process.
Yes.
On this note of the bailiff, right? There are so many horror stories. People come home, can't get into the property for various reasons. What are the parameters? What are the do's and don'ts of a bailiff?
Well, so once you use a certified bailiff, and normally use a court's bailiff to do these type of proceedings, the bailiff is entitled to come lick off the lock and throw you out. Quote unquote, put you out, because they would have gotten an order from the court. Now, if it is that you are a tenant, what you need to know in terms of protecting your rights, the bailiff can't just show up and put you out. There must be a court order in place. So it's not a case where you can just jump that step. So if you weren't taken to court, or you did not show up to court and an order was made, that will empower the bailiff to act. So anytime when you are being evicted, if the bailiff does not act within proper recourse, then you can have a case against your landlord. So even though you are a tenant, you have rights and the landlord have rights. It's just that I believe, in my opinion, the law favors the tenant more, because there's a lot of leniency involved.
Is it legal for us to have a deposit?
Well, yes, you ought to have a deposit. So you have a deposit. What people tend to misunderstand is that you can't just tell the landlord, oh, I'm living out, my deposit. Your deposit is not to live out. Your deposit is a security in the event that you would have damaged anything on property, or you would have to compensate the landlord for anything on the property that is outstanding. So it is a security in relation to the property.
So if the landlord is not living up to his end of the bargain, can I withhold my rent if I'm taking on those expenses?
I would not advise that. He would have been a breach of keeping the property in good repair. So what I would advise anybody is to take your landlord to court, but do not withhold rent, because then he can have an upper hand to say that you're not paying rent.
There is a very popular thing happening. No dogs, no young children.
Yes.
I only want a female of this age and working at this kind of industry. Can that happen? Is that legal?
It's your property. To be honest, it's your property, so you determine what you want. Some persons will purchase their property for investment, and they want to ensure that the tenant in which they have is someone of certain caliber, to ensure that they preserve the investment.
For persons whether trying to acquire a home or go into a rental property, what is the one piece of advice to anyone who is on that journey?
Well, I would say, when you're buying a property, ensure you pick good location, something that will appreciate over time. It makes no sense you buy into a community home because it's cheap, because 9 out of 10 times it won't accumulate much in value. But when you purchase property, look at the surrounding features of the community. If it's developing, if it's a community that 10 or 15 years I can see my child, running on the street and not be prone to violence. So that is important. Location, 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 and location. Yes.
There are so many things to consider when acquiring real estate. Thank you for joining us today for our property tour and our legal conversation with Michelle. Join me next time on The Listing. I'm Angel Alicia.